All right, hello and welcome everyone to Phoenixville Public Library, either virtually or in person. I'm Mark Pinto, the Adult Services Director here, and we're pleased to have with us in person tonight Kelly Young, who is a staff attorney with Legal Aid of Southeastern Pennsylvania, and she will be presenting on landlord tenant law and the basics of eviction defense. We ask that you hold your questions until the end of her presentation, at which time you can either type in the chat or unmute yourself if you are on Zoom. Okay. All right, Kelly, welcome. Take it away.
Hello, good evening, everybody. Thank you, Mark, for doing the introduction. I, as Mark said, am going to talk for hopefully about 40 minutes about landlord-tenant law and how you would go about defending and handling an eviction case. It's a very unfortunate situation, but it does happen. So it's helpful to have some information and background. So it makes sense to start with the relevant laws, right? Where are we getting the information that dictates how the landlord-tenant relationship will proceed? Most importantly, the Landlord-Tenant Act of 1951. Thank you, Mark. And yes, it is 70 years old, but that's the one. When you read through it, you can definitely tell that it's 70 years old, and there are some parts that are not really relevant anymore. We are mainly looking at, well, I am mainly looking at, when these situations arise, Article 5, which is about recovery of possession. The biggest deal in a landlord-tenant case is the house. Who's going to get it? Can the tenant still live there or not? I'm not really going to talk about the Fair Housing Act, but it's of huge importance in landlord-tenant relationships, so I put it up there. The Fair Housing Act and 1988 amendments, of course, prohibit discriminatory behavior in the sale or lease of housing, an advertisement of housing. And the protected classes are race, color, national origin, religion, sex, disability, and familial status. And familial status includes whether or not you have children. The other very important source of information is previous cases in Pennsylvania, because this has been going on for a very long time. And pretty much everything out there has already happened. So I put on the screen Pugh versus Holmes, because that is my favorite case, and that's a great case for tenants. We really don't have any, that's the main source of the implied warranty of habitability. So your right to a safe and sanitary home. Doesn't necessarily get enforced all the time, which is sad, but it is in Pugh v. Holmes. And that's not new either. That's 45 years old. When you're looking at how does the court function, what's allowed, what has to be filed, and what are the timelines, we're not really looking at a law. We're looking at the Pennsylvania Rules of Civil Procedure, which are, if you just Googled PARCP-MDJ evictions, most likely, they would pop up. They're all on the Pennsylvania website. And then the last thing, one of the other incredibly relevant things in your landlord-tenant relationship is your lease. And most people think that's obvious, but there's also a lot of people who don't think about that. Maybe they're starting to have a dispute with their landlord, and they're calling me, or they're talking with family, and it never comes into their mind. Let me consult my lease and see what it says in paragraph 9. Maybe they haven't looked at their lease in 10 years. Some people have been renting or 30 years. Okay, so like I said, the Landlord-Tenant Act of 1951 is the act that requires that evictions happen in court. There is no, well, you didn't pay, so I'm going to lock you out. There is no, I'm going to call the police, and the police are going to put you out. The police are definitely not going to do that. They're going to say what they always say, which is, this is a civil matter. Everybody calm down. You're going to need to handle this through the civil court. So like I said, it's mainly Article 5, which you can see I put a picture here. That's just the beginning of Article 5. Very exciting picture. And it starts with the requirement of a notice to quit. which we'll talk about later, but a landlord desirous of repossessing real property from a tenant will notify in writing the tenant to remove from the same at the expiration of the time in the notice. So, in plain English, you write on a piece of paper, please quit by next Tuesday, and then you give it to the tenant. That's all that the notice to quit is. It's from the landlord, it's very simple. But the act, it covers, you know, who will preside over this issue, which judge in which court, how will the tenant be notified of the eviction. In the certain situation, is payment gonna be enough to stop the eviction? Is it not? Does the tenant have a right to appeal? And also, if the tenant is ultimately evicted, what happens to her property? Because a lot of times when people are evicted, it's very traumatic, and you didn't necessarily pack everything up neatly and move it away in a U-Haul. You may have left some things behind. Okay, so I thought maybe we would just start with habitability because it's a big concern for a lot of people, and it's you know, the Landlord-Tenant Act gives us some of our rights, our right to a notice to quit, right to go to court, other rights we get from the Fair Housing Act, but the implied warranty of habitability is not written in a statute or a law anywhere. So I thought that I would talk about this first. It's from Pugh v. Holmes, like I said, and I brought copies of the case. I don't know how interested people are in reading Pugh v. Holmes, but it's 11 pages, and it's quite interesting because it's from 1979, but describes a lot of the same things that are happening today. And I highlighted a couple paragraphs. So the court in 79 was actually quoting a previous court decision from 68, even longer ago, and says, stark necessity very often forces a tenant into occupancy of premises far from desirable and in a defective state of repair. The acute housing shortage, that sounds familiar, mandates that the average prospective tenant accede to the demands of the landlord as to the conditions of the rental, which under ordinary conditions with housing available, the average tenant would not and should not accept. So I do know a lot of people right now searching for housing and somewhat desperate and getting to the point where they're willing to accept anything, or they have to accept anything. And that's a problem and gives landlords kind of a pass. The court points out that no longer, way back in 68, does the average prospective tenant occupy a free bargaining status, and no longer do the parties negotiate on an arm's length basis. So the court's recognizing that this is not an equal power relationship, and the court therefore states the implied warranty of habitability, says, you know what, we're gonna have this warranty of habitability, and it's a promise by the landlord to provide a safe, sanitary, and healthful home that can't be waived. So even if your lease says you're accepting the property as is, okay, that's true, but not meaning 2 years down the road, if the heat stops working, well, too bad, the property is as is. And even close to the beginning of occupation of the property, if there's a significant issue, then you can notify the landlord and say, I believe this is a violation of the implied warranty of habitability. I went backward. Oh, and I have a picture, this picture here, okay, we're gonna get it. Forward is this way. Yes. This picture here is from the Know Your Rights as a Renter packet, which is quite hefty. I think it's like 50 pages, but it's fantastic. And it explains almost every aspect of the landlord-tenant relationship. So I brought some of those as well. So what types of things are covered? You need hot water and running water. You need a sewage system. You need to lock the door. You need heat. Serious roof leak, not okay. You need electric, and also some other safety issues like loose railing, broken stairs can be considered a violation too. It's not cut and dry. You have to look at the situation on a case-by-case basis and think, is this problem affecting my ability to live like a human being in this dwelling? So you're not gonna be able to say, oh, the carpeting is really bad, that's a violation. Or, oh, the place hasn't been painted in 30 years. It really doesn't. That's not a violation. It's not making it impossible for the house to be inhabited by human beings. So if this does happen to you, I recommend, first you just be a normal person, right? We talk about it. We just call the landlord and we say, hey, I'm having this problem, and usually the landlord comes and fixes it and it's no big deal. You only need to proceed to this if that's not working and you feel that you're sort of being left out in the cold. So in writing, can be an email, can be a note that you hand, can be a text, but I would make it a bit more formal if it's a text. You say, hey, this is the situation that I'm dealing with. I'm asking that you address the situation. Describe how it's affecting you and how long it's been going on, and be specific. And then ask for a repair within a certain time. You design the time. It just has to be reasonable. So if you have no heat, hey, can you please get this fixed within 24 hours or 48 hours, depending on what time of year it is. But if it's a broken railing, maybe you can say, I'm asking for help with this issue within the next 2 weeks, right? And make your letter, even though you're probably upset at this point, make your letter polite and professional, and at that point, hopefully there will be a response. If there's not, then you've set yourself up to send a second letter that says, basically, I haven't heard from you, and therefore, I will begin to put X amount of rent into escrow. If it's a huge problem, okay, escrow your whole rent. If it's a problem that you feel, affects 50% of the livability of the home, you could be reasonable and escrow 50% of the rent. And when you escrow money, I would put it in an empty savings account. Put it in a bank account where you can show a statement if something does happen that involves the court, or you can show a statement. And you'll be able to say, here's my first letter, here's the date, I signed it, here's how I delivered it, here's my second letter, and here's my rent money. So no, it's not that I couldn't pay my rent. It's that I had an issue with the habitability of my home. And then I just have a note at the bottom, because you have a right to a habitable home, and therefore, sometimes you have to escrow your rent. But escrowing your rent should not be done lightly. It is probably going to cause the landlord to file an eviction complaint claiming non-payment. And that's a civil record of that filing that will never go away because there is no civil expungement. So I just say, just be thoughtful about when you're going to do that. And you can always contact legal aid.
Did something get cut off on that?
I believe it said, if you are uncertain, we recommend you contact legal aid.
Okay.
So, sorry about that. All right. Oh, I wanted to read from QV Holmes one more thing. So the court says to us that the implied warranty is designed to ensure that a landlord will provide facilities and services vital to the life, health, and safety of the tenant. The warranty is applicable at the beginning of the lease and throughout its duration. And like I said, this is all from the case, everything that I said. A breach of the warranty must be of a nature and kind which will prevent the use of the dwelling for its intended purpose, to provide premises fit for habitation by humans. So it is an interesting case. I recommend it for bedtime reading. Okay, let's see. So, other than Pew v. Holmes, which gives you your right to a habitable home, you have your lease. Your lease gives you all the rights that are in there. So, again, seems basic, but always keep a copy of your lease. It's a very important paper. You should put it in, the kitchen drawer or a special folder where you keep your important documents. If you have a question, you look at it. Before you sign it, you look at it. Because again, there's lots of people out there competing for apartments, and you might feel you should just sign whatever you're given, but you can be reasonable. If there's a clause in there that's just, maybe there's a waiver of the notice to quit, like we can sue you without telling you. Maybe it's worth it. Maybe you won't lose the apartment if you say, hey, I think it would be nice to have a 10-day notice so that we could work things out. Can we just cross this out and write that in there? Lots of times they do it. And the other important thing is, say I have a lease from 2011 to 2012, and I'm still living in that place, but that's the only piece of paper I have signed by both parties. That's fine. That still governs our relationship. Obviously, the dates have expired and are not relevant anymore, and the rent may also have gone up. The landlord could give you, tell you that the rent's going to go up the next month, or give you a written notice that the rent went up without having a whole new lease signed. So you do need to keep your most recent written lease will dictate your rights and relationship with the landlord. Okay, so you have these rights from the Landlord-Tenant Act, and you have the right to a habitable home, and you have the right to what's in your lease, such as I can use the premises without you walking in and disturbing me, and I can have guests for up to 14 days. I can have 3 pets, whatever it is. The landlord will maintain the property, whatever it says in your lease. So say that we have 2 parties, they contracted in a lease, and now a dispute has arisen. Where does it go? It goes to the court, and it goes to, I'm kind of feeling like this is a pointer, but it's not. It goes to the lowest court. I like to call it the small claims court because it makes it seem a little less scary and more accessible. And it is called the small claims court, but it's more formally called the magisterial district court. So in Chester County, I was going to bring a copy of the directory of magisterial district courts. You can find it online. There are 15 to 16 of those. It's the bottom of the pile, the most accessible court. It's not designed to require attorneys. It's actually designed so that laymen can go in there and argue over small claims that they have against each other. You said you would pay me back this loan of $4,000 and you didn't. So the 2 of you go to court and don't have to waste a bunch of money on a lawyer. It's under the Court of Common Pleas, which is where you would go if you take an appeal. And the Court of Common Pleas is, of course, in the county seat, Westchester. Used to be the beautiful courthouse on Market and High, and now it's at the bottom of the hill on Market, called the Chester County Justice Center. Then you go up to the intermediate appellate courts, and then you go up to the Pennsylvania Supreme Court, which would be more like what you see on TV. So, and then magisterial district courts is what they're called everywhere in the state besides Philadelphia. In Philadelphia, it's called municipal court, and it's a little bit different. And there are more protections for tenants in Philadelphia. Okay, so it goes to court, and what happens? The same thing happens every time. It's always the same. Actually, this timeline starts before court. You can see the notice to quit is the first thing. But if the notice to quit is not heeded by the tenant, or the tenant disagrees and so the tenant doesn't leave, the landlord can file a complaint in the court. That's the first contact with the court. It's a very simple form, 1 page. They make it easy for the landlord. Landlord fills it out. The court serves it on you. It will come by constable, and it will usually be 3 pages of information. The first page just tells you when and where your hearing is. It's going to be in your local district court. So if you live in Phoenixville, it's going to be in Phoenixville. If you live in Downingtown, it's going to be in Downingtown. You will be, so first page, when and where. Second page is the complaint, the most important piece of paper, what the landlord thinks that you have done wrong. Third page is usually something that the landlord has to sign saying that they looked into whether or not you were in military service, which they often don't actually look into it, they just sign the paper, which is not allowed. So your hearing will be about 10 days after the filing of the complaint. It's quick because the state recognizes that people are very interested in their property and want to get their money. So this process moves along quickly at the beginning. You get notice of the hearing. The hearing takes place, and within 3 days after the hearing, there will be a judgment. Now, the judge simply goes onto their computer system and enters judgment for plaintiff or judgment for defendant. A notice of judgment comes out, that's also 3 pages, gets mailed to you. Mail can be slow, so if you have just had a hearing and you're anxious about what the decision is, because that affects, you need to know, so you need to know if you want to appeal or not, you can always call the magisterial district court, and the people at the front desk will probably email you the notice, or you can come pick it up. You know what? I don't think this is exactly right. I'm very sorry. I should have reviewed this. If you look at the judgment square, this is what happens next. There's 10 days. There's a 10-day pause. Nothing can happen for 10 days because you have 10 days, and so does the landlord, to decide if you want to appeal. Now, if you don't appeal, then on the 11th day, the landlord walks over to the district court and says, I want an eviction order. They can't ask for it until the 11th day. And if they ask for it, it will be scheduled again for 10 days out. So the shortest amount of time that there can ever be between the hearing and the actual eviction of the tenant is 21 days. 10 days for the appeal pause, 1 day to ask for the eviction order, 10 more days until the eviction. And you will be notified those 10 days before the eviction. So that's very little time to move everything that you own, but you will be notified again by the constable with the order for possession, which is the eviction order. Okay, so 3 main reasons that the landlord might file the complaint. It's all very basic. Number 1, for money. I don't think the tenant paid the money that was due under the lease. Number 2, for other lease violation. Not paying the rent is a lease violation, but it's a very specific and very common one that's handled in a different way. Number 2 is other lease violation. You had a pet when I said you couldn't have a pet, and well, when your lease said you couldn't have a pet. You had guests for more than 7 days, and that is an unauthorized resident. That's a violation of the lease. Whatever the landlord is alleging there. Number 3, the lease term has ended. So, and this one really pains me because, we care a lot about our private property rights and our freedom of contract. And if you have been living in a home for 20 years on a year-to-year-to-year lease, and your lease is up at the end of every year, then suddenly, for no reason at all, after 30 years, you can receive a notice of non-renewal of your lease. And that's just devastating and heartbreaking. But it is the simplest case for the landlord. There's no legal defense because either party has the right to end a contract. Okay, when you get the complaint, you have to look very closely at the complaint. The complaint dictates exactly what the landlord will talk about in court. Well, not always. Sometimes the landlord writes on the complaint, I don't think you paid the rent. And when you get to the hearing, the landlord says, and also, you have a dog, you have a boyfriend, you made a hole in the wall. And none of those things are actually allowed if the landlord didn't write them on the complaint. So I have 2 complaints up here. The one on the left is just for money. You can see there's these little well, you might not be able to see, I'm sorry, but the check boxes are different issues. Rent remaining due and unpaid, notice to quit was given, the term for which the property was leased is fully ended, that's the non-renewal, or a forfeiture has resulted by reason of other violation, and then the landlord has to write in what it is. You can't just check the box, you have to write in what it is, because that's notice to the tenant what you're gonna argue about. So this one over here is just money. The only thing that should be discussed at the hearing is money. And if the landlord comes in and brings up a lot of other issues, the tenant should say very politely, well, Your Honor, I object, because that's not on the complaint. And that means I didn't have notice. How was I supposed to prepare to defend against having a dog when it didn't say that on the complaint? The complaint on the right is for rent and lease violations. So the landlord has written in here, checked off the box, a forfeiture has resulted by reason of breach of conditions of the lease, to wit, of course they have to say to wit, and it says breach of lease pet violation. So in this hearing, yes, you're gonna be talking about the money and the pet. And it's very important what's claimed, because that can dictate what kind of judgment results from the hearing. There are two types of judgments in a landlord-tenant case. Well, there are three. One of them is the tenant wins, which does happen. Another one is a pay and stay judgment. I call it a pay and stay. I don't think the words pay and stay are really used anywhere in the Pennsylvania Rules of Civil Procedure, but it's statewide. All the legal aid staff attorneys say pay and stay. And that means the only claim against you was money. And yeah, you didn't pay the money, you know, it's true. So there's a judgment entered against you for that amount of money, but you have the opportunity to pay it and stay. You have all that time in this timeline, minimum of 21 days, to get together that money and pay it. And if you do that, there will be no eviction. You can pay it to the landlord at any point before the eviction, or you can pay it to the constable when the constable comes on the day and time of the eviction. If you wait to pay the constable, if you don't have all the money until that last minute, then the cost goes up a little bit, because then you're also paying for the constable to come out and evict you. Okay, so you have the pay and stay judgment, which it's so much better than the other option, because yes, you lose, but you can cancel everything by just coming up with the money, easier said than done, that you didn't have before. If there were other lease violations alleged, and the judge listens to both of you and believes the landlord, then you're not gonna have a pay and stay. You're gonna have what I call a straight possession judgment. So, you know, and it's very important to know the difference, because I've talked to multiple people who get their judgment paperwork and it says, you know, $1,000 is owed. So they're like, I can do this. So they get together the $1,000 and they pay it to the landlord, and they don't think they're being evicted because they paid. And on the day of the order for possession, the constable comes and they say, but I paid, and the constable says, but you didn't have a pay and stay judgment, you need to go. And you know, it's good that, I guess, that the landlord was made whole with that money, even though the tenant's leaving, but sometimes the tenant needs that money to go to their next residence. I mean, you need a home. So it's very important to know, is paying this off gonna help me or not? And you will see at the top which type you have. The pay and stay will say, possession is granted. Oh, wait a minute. I have them reversed. Again, mistake, I'm very sorry. The pay and stay will say, possession is granted at any time before actual delivery of the real property. The defendant may satisfy the order for possession by paying the rent in arrears. Okay, and that amount of money that you would have to pay is clearly written on your order for possession. If you do not have a pay and stay, it will just say possession is granted. You're not permitted to satisfy the order. Okay, at the hearing. So what happens at the hearing? Very small courtroom, not like what you see on Perry Mason. Usually just the judge up on the higher seat, the plaintiff, which is the landlord, and the defendant, which is the tenant. Usually those are the only parties in the room. Some of the courts in Chester County will allow people to sit in the back, but most of them, in my experience, do not. The plaintiff always presents first. So the landlord talks first, which can be frustrating, because sometimes it seems like whoever says their piece first is gonna be the one that the judge believes, but not necessarily so. So my best advice is to wait patiently while the landlord is presenting her case. You disagree with everything the landlord is saying, fine. You have to be respectful and polite, because that's only going to improve your credibility with the judge. You can make notes, you know, bring a notebook, bring a pencil, and note down what you want to respond to when it's your turn. You can interrupt if you have an objection, but don't interrupt to just say, oh, no, that's not true. No, that's wrong. Because that's not helpful. That's not helping, the judge will be frustrated with you. That's not helping the judge understand both perspectives and the whole story. So the landlord talks first. You will have your opportunity. It's best to wait. Focus on what's in the complaint. So if they start going off the rails, yes, you can object politely. I object, that's not on the complaint. You can bring really whatever you want to bring, but you should be mindful to bring only the least that you need to bring. Again, for purposes of not frustrating the judge and keeping things clear and simple for the judge. If you're going to bring paperwork, well, I should say if you're going to bring documents, print it and bring paperwork. Don't show it on your phone. Some of the judges don't even allow that. Others allow it, but it's still not as good. You should print out what you want to bring. You should bring 3 copies. That way, when it's your turn and you want to share your paper, you give 1 to the landlord, you give 1 to the judge, and you have 1 for yourself. You can all look at the same thing. You can bring a witness. So paperwork you might need if, say it's a non-payment case and there's been some disputes over payment and you have all of your payment receipts. Well, print those out and bring them in a very neat pile. You can bring witnesses if the issue is that you were, too noisy and you violated other tenants' quiet enjoyment, and that's a violation of your lease, you need to go. You can bring a neighbor who's very familiar with you and can testify, well, I've lived with this person, next to this person for 3 years and it's never been an issue. They're a good member of this community. Sometimes it's difficult to bring a witness because the person who sides with you doesn't want to get into their own beef with the landlord. So it's perfectly fine not to have a witness. You can also just have yourself. And you should prepare. You should make some notes with your points. And you don't have to be fancy. You don't have to label your exhibits and say things like, may it please the court. It's very informal as courts go, but you should still show your respect in being prepared ahead of time. I have a picture of the complaint again, because when you're in the hearing, it's always good to have a complaint right there in front of you so that you can reference it and you can keep the conversation focused on what's in it. Okay, I wanted to talk about I thought I had a video in here. So I do want to talk briefly about the lease term because the non-renewal of lease is that of the 3 reasons for eviction. The non-renewal of lease is just the kicker, and I hate it. And there is really no argument against it. And it can be truly tragic. But I've had situations where maybe there's a little spat and the landlord decides that she's tired of the tenant and just turns around and gives a 30-day notice of non-renewal. But in fact, it's not the end of the lease. So again, you do have to be attentive to your lease term. I've had situations where someone's been living in the house for maybe 3 years, so they haven't looked at their lease in a hot minute, and maybe they don't even have it anymore. They have to get another copy from the landlord. And they have a little spat, and then they receive a notice, and they call us, and they're panicking. And I say, well, what kind of term are you on? And they say, month to month. It's just month to month. We don't have anything in writing. And I say, did you ever have anything in writing? And they say, oh yeah, a couple years ago. So they pull that out from the attic and send it to me, and lo and behold, it's a year term that renews year to year and ends every year in March. And here we are in September. Well then, okay, the landlord's upset, with the beef that they had, the little argument, but it's just not allowed to non-renew. So I have an example here that shows that situation, and it's happened multiple times. And when you push back, the landlord will be upset that they were wrong, they didn't catch it, but that's your right to live out the end of your lease. And then if the landlord wants to make you leave, they're gonna have to, the argument, whatever you whatever happened is gonna have to be bad enough that it rises to the level of a lease violation. The landlord's gonna have to prove that in front of the judge so that they can get a straight possession order. Like I said before, when no new lease is signed, that's okay. It's good to have a new lease, keeps all parties on the same page, keeps it fresh in your memory, but if you only have the one from 2010, it still controls. I think this website is fantastic, palawhelp.org. You can click on, I have a picture of the housing page. They recently changed the formatting, so there are just these squares for each topic. Most of them have been written by a legal services organization like Legal Aid of Southeastern Pennsylvania. There's Mid-Penn, there's North Penn, there's a bunch of other ones. We all do the same thing, and there's great materials on this website. There's also other topics. You know, you don't have to click into housing. You can click into public benefits or healthcare or family law. So this is a good resource for really for everything. And I had a video that I thought I might share, but maybe we'll skip it because I don't know if I can do that. There is one of these pink squares on here is an actual video, a little skit that I think it's Northwestern Legal Services put on, where they show you the magisterial district hearing. So you watch the people come in and the judge states the name of the case, the landlord presents what he's upset about, the tenant is very patient, and she waits until her turn. I'm sure they instructed the actress to do that. And then the judge has questions for all parties. So it's kind of long, it's like a 40-minute video, but it's very interesting, and it's definitely from the 90s. But not all that much has changed in the world of landlord-tenant. Okay. One of the things that has to happen, remember back to the blue timeline, the court timeline, complaint, hearing, judgment, appeal period, order for possession. The first blue block was notice to quit. And again, it's not an official document. It could be written on a sticky note. I mean, maybe a sticky note's not quite good enough, but it could be on a half piece of paper in your landlord's handwriting. And it could just say, you owe rent, this is your notice to quit, please leave in 10 days. But you have to have it unless your lease waives it. It's an absolute requirement in the Landlord-Tenant Act of 1951 that we had in the beginning. It's an absolute requirement. And there are cases out there, and there are even sort of instructional guides for landlords that you can find on Lexis, the law search engine and things like that, that specifically say this is a prerequisite to a case, to a court case, and it's jurisdictional. If you didn't give the notice to quit and your lease doesn't waive it, then the court has no jurisdiction. And I've been successful with that before, and you don't need a lawyer to do that. You can go in there yourself and say, here's my lease, I read through the whole thing, it doesn't say that the notice to quit is waived, and I didn't get one. So at that point, the judge will say, landlord, I'm sorry, but that's a jurisdictional requirement, and there's a judgment for the defendant. The defendant wins. Of course, the landlord's gonna be really mad, probably walk home and slap the notice to quit on your door that very day. But it could be an important additional amount of time that you really need for your housing. Actually, thought on that, sometimes you also have to keep in mind every time the landlord files a complaint, it's a civil record. So what I have done sometimes, depending on what everybody wants, is if you notice there's a notice to quit issue, a technical issue with the court's jurisdiction over the matter, but you don't want the case dismissed, or you don't want to win the case, because then the landlord, like I said, will just file again right away, and there will be two civil records. You can talk to the landlord out in the hallway and say, hey, this is actually a very important rule, and you didn't do this. So what about we agree to continue this for 30 days? And then you've bought yourself 30 days to work on whatever it is. Finding another job, catching up on money. All right, so I have just inserted, this is what it will look like in a lease over on the left. Waiver of notices. It could be on page 2, it could be on page 14, so you really got to read the whole thing. But it's just one sentence. Landlord shall not be required to give tenant a notice of default. Tenant waives the right to a notice to quit. So that little tiny sentence means you don't have to have any hint that there's about to be a civil record created that will never go away. If I had the opportunity, I would negotiate that out. It's nice to have a little warning and be able to talk about the landlord with it, about the issue. Okay. You should also check your lease for unenforceable terms. So, maybe the issue on the complaint is non-payment, and the amount claimed is $1,500. And the reason it's $1,500 is there's the principal monthly rent and a bunch of late fees. There are leases all over the place that say the late fees are $50 and then $5 every day. That's not technically allowed. You might have to explain that to some magisterial district judges, but a lot of them already know, and if you bring it up, they'll go with you. In a contract, the Pennsylvania law says that in a contract, the only thing allowed is a liquidated damages clause. So you can have a clause that says, well, if you're late, it's gonna hurt me, and it's gonna hurt me in this amount. I'm estimating the amount that it's gonna hurt me, and this is it, $100. But you're not allowed to have a penalty clause. Penalty clause is unenforceable. And when the lease says, and I've even seen them say $20 a day, and when the lease says that, that is obviously to put pressure on the tenant and scare the tenant into paying on time. That's not allowed. So the amount of money claimed on the complaint might be wrong. You have to go through that. You have to look at your lease, see what the late fees are. Like this one here, it says rent. Where does it say it? If rent is more than 5 days late, tenant pays a late charge of $50 per week. Nope, it would be a late charge of $50, not $200, and that's a big difference. Some leases will have a confession of judgment clause. It'll say in there, if the tenant defaults, I, as the landlord, can enter the property and retake possession. No, because we have the Landlord-Tenant Act of 1951. You have to go through the court. So I have an example here that says that the lessee is irrevocably authorizing the prothonotary, which is the filing office, the court, or any attorney of any court to enter judgment, to confess judgment without process, without a hearing. And that's never going to happen in Pennsylvania. And if you have something in your lease that just hits you wrong, and you're like, I don't think that can be right, you can call legal aid to ask. Okay, so if all else fails, you don't have the notice to quit defense because it was waived in your lease, or because you got the notice to quit. You are properly at the end of your lease, and there was a proper non-renewal, right? Not 45 days when it says 60, not 29 days when it says 30, 30 days or 60 days notice of non-renewal, depending on what it says in your lease. Again, if you went to the hearing and you gave your best credible testimony about the fact that you did not have an unauthorized resident, but the judge is determined to agree with the landlord, and you get a judgment against you, and you do not appeal, then you will be facing an order for possession, and it looks like this, and it's the only way that you can be removed from your home. It's 2 pages. You see the first page there in the middle has the time and date. Don't let the second page confuse you. The second page always has this form language. If necessary, eviction will commence on blah, blah, blah after 12:01 a.m. Constable's not coming at 12:01 a.m. It's usually 9 or 3, and it'll say that on the sticky. Okay, the appeal. If you disagree with the judgment, you appeal. Sometimes, if you just, you have kids, or you dealing with a disability, and you really have nowhere to go, maybe you don't exactly disagree with the judgment, you can still appeal just to buy yourself more time. And that is always done. That's the Chester County Justice Center. In person at the Chester County Justice Center, there's about 15 pieces of paper that you need to compile. We have pamphlets about how you file an appeal, and there's also information on our website. There's information on palawhelp.org. You can call legal aid for directions on how to appeal. And some judges explain it a little bit at the end of the hearing. But you walk in, you have your paperwork in order, you file it, and you pay your bond. So I'm from legal aid. We're dealing mostly with tenants who are currently struggling, low income, difficult financial situation. In those circumstances, you don't have to pay off the whole judgment in order to appeal. You only have to be prepared to pay 1/3 of 1 month's rent, which makes it very much more possible to appeal. Sometimes that's only $350 that you have to scrape it together within the 10-day appeal period, or no dice. But if you're not below that, about 150% of the federal poverty line threshold, then you are going to have to post the amount of the judgment to file your appeal. And as the appeal goes on, you need to deposit the rent every month. That's everyone, regardless of whether they're experiencing low income or not. What do I want to say about appeals? When you file the paperwork, which again, you have a right to file the paperwork. You're not filing the paperwork and asking for them to allow you to appeal. You have a right. You file the paperwork, and the court date is automatically set for 6 months out. So, paperwork will happen in that time. There will be a new complaint, fancier than the one that we saw. You will have to answer that formally on a piece of paper in pen. There could be discovery, which there usually isn't in landlord-tenant cases, but is a formal court process of gathering information. But as long as you keep up with that paperwork requirement, you do your answer, you pay your rent every month, you will be entitled to stay in that house for those additional 6 months until the hearing, which will make your landlord very upset. But it's really a huge saving grace for a lot of families who find another apartment in 3 months. Maybe they had a non-renewal and it was just a really tough situation, and they couldn't find an apartment for 6 months, even though they looked and looked and looked, and I hear this all the time. Maybe they file an appeal so that they're not homeless for a period, and then they find another place. When you find another place, you call the landlord up and you say, hey, I found another place, let's end this litigation. So actually, if you want to stay in the house, you have to appeal within 10 days. If you don't want to stay, if you're leaving anyways, you have 30 days. And that is about it. So if you are seeking help from legal aid, you can call our helpline any weekday from 9 to 1. Sometimes it's hard to get through, so stay on the line and wait for someone to answer. I believe there's exciting music. And if you can't get through, you can try again, give it half an hour or so. You can also apply online, but I'm told that you might not get a response as quickly if you apply online. And then these are the other websites where you can get information. My favorite is at the top. It's very accessible to laymen, people who don't have a legal education. There's also all of the forms that I shared up here, the complaint, the order for possession, appeal paperwork. It's all on pacourts.us/forms. So that's about it. If anybody has any questions, I
Okay,
could answer those.
and feel free to unmute on Zoom or type your question in the chat. Anybody in the room go first?
You mentioned Section 8 housing, whatever, and then you also mentioned how important the lease is.
Mm-hmm.
I've both owned homes and rented homes, and it's amazing now. Every year, luckily, they send a renewal of the lease, which is close to 40 pages.
Oh.
It's almost like you need an attorney to possibly help you interpret it. Mm-hmm. And each year it gets more complex. Somebody said that I've had my real estate license 40 years, very part-time. I flipped a couple properties, getting more interested in the commercial end. The lease is intricate. And I know I'm kind of summarizing, I know there's a lot of people that are looking for housing. A lot of retired veterans are
Yes.
Struggling, widows,
Yeah.
can't pay the taxes. It's just wonky right now, but you almost need an attorney to help you interpret it, because every year it gets a couple pages more. 40 pages is a lot to read and to interpret, and then when you say, well, if you don't like this, talk to your manager, rental manager there. You have to be careful of having, well, strike this out. Make sure that an attorney is working with you, because I've learned over the years, they require this. But it's just a standard form that you use. They're using it internationally, and it's scary. It's scary.
Yes, I had a couple thoughts.
I know.
And of course they're all gone.
I tend to ramble with my
I need my
walking.
paper and my pen so I can talk right while you're talking.
Maybe we get a
you
copy
said-
of what you said.
Oh, yeah,
that we
absolutely.
could read.
When we're done,
Okay.
you can come up, and I just didn't have a lot of space to put them out. Or maybe I can get you one now. But
Yeah.
you said I mentioned section 8. I don't think that did I mention section 8?
Yes, you did.
Okay, there is a lot to know about section 8, but we didn't talk about any of it.
I know.
Section 8, yes. So the Housing Authority of Chester County runs multiple programs. Section 8 is only one of them. Section 8 is the Housing Choice Voucher Program.
Voucher.
And the Housing Choice Voucher Program is where a tenant can rent from a private landlord, could be me. I have a house that I'm renting out. As long as I say I'm okay with accepting the voucher. If I don't want to, I don't have to, which is a terrible rule. But yes, I can say, sure, I'll accept the voucher, and then every month I get money from the Housing Authority. And I have a lease with the tenant, which can be whatever lease we want. I mean, some of those leases are 2 pages because I'm designing it with the tenant. I literally see 2-page leases in my job, like fairly often. Usually they're old, but the people have been there for a while. And I also have a contract with the Housing Authority, which is called a Housing Assistance Payments Contract, which is, I believe, 13 pages. And yes, it is confusing. And yes, if you ask the Housing Authority to explain things to you, you still might not understand. But there's another type of subsidized housing called low-income housing tax credit housing. It's not actually subsidized housing, it's a tax program. And those have, 40-page leases.
Yes.
That's like, we're talking about like, what is it called in Hopewell Manor? Is that it?
I think so.
French Creek or
Yes.
Red Clay down in Kennett. Those are all LIHTC, and those leases are very long. There are some rules to keep them plain language, but it's not all that plain.
I'm renting right now present in Phoenixville, and their standard lease is 40 pages.
Yes. So if you're considering an apartment and the landlord sends you the lease and says, sign this and send it back, and you're like, well, I have a question about paragraph 10, 12, 15, 19, and 30. You can call the helpline and you can speak to a paralegal. I can't guarantee how quickly you'll be able to get in touch with a paralegal, but hopefully a live person will answer the phone and you can ask those questions. And we have paralegals and we have lawyers at the helpline and the paralegals are just as experienced as the lawyers. I mean, they're really good. But yeah, that's another good point. A lot of places aren't going to let you negotiate. Like if you rent from a big corporation, one of these places like the Metropolitan in Westchester, they're not gonna say, oh sure, we'll take out that clause because you don't like it. I mean, that's corporate, so that's the lease and you can like it or you can not, and then you can not move in.
Can I ask a question?
Absolutely.
If you had a standard 1-year lease, and like you said, maybe 3 years down the road, if it doesn't specifically say that the lease, in the terms of the lease, it doesn't specifically say that it renews every year on, say, December. after that 1 year is up, is it then a month-to-month lease? Or?
Yeah.
Yeah,
Mhm.
okay.
Yeah. Sometimes I see leases that say
Our specific leases.
the lease is from July to June.
It goes to, or it's month.
Sometimes I see leases that say this is July to June, and it doesn't say anything about renewal. But then later on it says that, you know, the lease ends and the tenant has to move out in June. So I would just make sure that there's nothing in there about it automatically ending, as well as nothing about automatically renewing. But if it's silent and you didn't get a notice, then yeah, you're still there and you're month to month.
And if you get a notice of non-renewal, is there, like, if somebody's been there a year, I think I was looking it up, and like it's 30 days if someone's been on a year lease. But if they're multiple years, it's maybe a 60-day notice to non-renewal.
So, I do not think so. There is something in, I have a couple of these, the Landlord-Tenant Act. There is, so the notice to quit, it's in 501B. A notice to quit in case of the expiration of a term, so that's lease non-renewal, or forfeiture for breach of the conditions of the lease, where the lease is for any term of 1 year or less, or for an indeterminate time. Can't really imagine that. The notice shall specify that the tenant shall remove within 15 days from the date of service thereof. So, I mean, as little as 15 days is sufficient for notice to quit in a case of breach or case of non-renewal, unless it says in your lease you get 30, and a lot of them do. That's just like the standard. When the lease is for more than 1 year, then within 30 days from the date of service thereof. So if you have a 2-year lease, yeah, you only need 30 days notice.
And you can't appeal a notice of non-renewal.
You can absolutely negotiate with your landlord. I mean,
Okay.
if it were me, because 30 days to move your entire home,
Right.
that's
Yeah.
like the blink of an eye. It shocks me every time, and I just don't know what to tell people.
Right.
So I would absolutely contact, and I would say, look, this is my situation, you know, what can we do? Can we do a 3-month lease? What are you looking for? Is there any other arrangement we can make that would make this more desirable to you? But if they say no, and they are just done for whatever reason, and you don't leave by the quit date, then there's a complaint. Then there's a hearing. There's really nothing you can say at the hearing. The judge will feel sympathetic, but will say, sorry, this is the law. They'll enter a judgment, and yeah, you can appeal. You can appeal. You have a right to appeal. And then you'll say to the landlord, gee, should have just took my deal for 3 extra months, because now I got 6.
Someone on Zoom has asked where they can get a copy of the Know Your Rights Tenant Landlord booklet.
Well, we have them here, and
Is it available online as well?
it's probably available on the Housing Equality Center's website. This is authored by the Housing Equality Center, which is a great organization. They don't do direct service in eviction cases like we do at Legal Aid. They do discrimination work. If your issue is that your landlord has violated the Fair Housing Act, which we very briefly talked about at the beginning, this process and the district court is not going to help you. You need to file a complaint with the Department of Housing and Urban Development. It's pretty easy to do it online. Housing Equality Center can help you with that. And they publish this, which has a lot about fair housing in it, but it also has a lot more. So definitely go on their website, and if you can't find it, then contact me.
Are you able to leave any copies of that here
Yeah, sure,
today? Okay,
sure.
that'd be
I'll
great.
leave some here.
Great.
Yeah.
Any other questions, people in the room or on Zoom?
I have a question about evictions.
Oh, sure.
So if you have been evicted, how likely is it that you can find another place to live without that affecting your
Yeah.
move?
Yeah, it's hard to say. There are so many people who have an eviction filing, you know, in the computer somewhere on their civil record, and they're still renting. But there are usually it's the big places like, and golf club is not a bad one, I don't even think they have this rule, but the big places like Golf Club Apartments in Westchester, or Rose Hill, or the Metropolitan, who might have a rule where, you know, they don't want any prospective tenant that has filings on the record. But pretty much all the clients that I talk to have been sued in eviction, and they all do end up renting. You have a lot more luck maybe with like a mom and pop landlord who don't care so much about.
Is there any way to get those removed?
No, there's no civil expungement. If you have a criminal record, there are intricate rules about what can be removed and when. But for civil, nothing can be removed. People are advocating for that all the time, though. There's a whole movement. Lots of people are very adamant that that's not fair because of the impact it has on your future housing. That's not fair. I mean, what if you didn't even do anything and the landlord's just upset, they file, and then that follows you around everywhere? So, unfortunately, no expungement. But the record will show whether you were successful or unsuccessful and whether you appealed, which can look good or bad to different personalities.
Question from Zoom. Do civil records show up on your credit report? And how would a landlord know if you had a civil record like a previous eviction?
Okay, so that's a good question, and there are lots of different companies. They're called tenant screening companies that do this for profit. Like, they scrape the court dockets using whatever software, and they provide a report to the landlord for a fee. You know, so you're going on one of these websites and purchasing this person's background, and it depends on the tenant screening company. Different companies' reports look different. It depends on what the landlord pays for, how thorough of a search they do. Like, if you go to a mom and pop landlord, they might not even do a search. They just meet you, do they like you? But if you go to, for example, Golf Club, they're gonna have a search that they do for every tenant. They're gonna have some company that they contract with all the time. And I can't necessarily tell you what they'll see. But they will likely see that you've been sued. Other question is your credit report. No, it's not gonna be on your credit report that you had an eviction case. If the judgment is for $0, say it's just a judgment against you for possession. You know, the landlord didn't sue for any money, just said you had a dog and you weren't allowed. And that's always gonna be a record, but that's not gonna affect your credit score because there was no debt. If you're sued for $5,000 and there's a judgment, then that's a debt, and that is gonna affect your credit score. I'm not sure to what extent. It won't be too severe just because of that one thing.
Any final questions? Okay.
Okay, thank
Great.
you.
Kelly, thanks so much.
Thanks, everybody, for
All right.
listening. Okay, so you wanted to have